Good morning and welcome to the Berks County Board of Elections meeting for July the 3rd of 2025. We'll call the meeting to order at 11 a.m. Just to let everyone know, we are transmitting live via Microsoft Teams. We are also recording, and this is new, we are recording the meeting and it will be then posted on YouTube. So the only live streaming right now is Teams, but it will be recorded and posted on YouTube, so if someone would like to see it at a further time. I will now ask Sylvia Gutierrez to read the public comment notice.
Public comment will be accepted in person and through the Q&A function. Please include your first name, last name, and municipality for all comments. Any comments without name and municipality will not be considered. Each citizen can submit one comment. Comment length is dictated by limitations of the platform being used, Teams Q&A. In-person comments will be accepted first, followed by comments submitted virtually. The meeting comment period is limited to a total of 30 minutes, including both in-person and virtual comments. This time period may be extended at the county's discretion. Please be concise. Comments that are germane to county business will be read during the meeting and should not be considered to be interactive dialogue. The county shall be the final arbiter of whether a comment is germane and should be read. Any response to public comment will be done at the county's discretion.
Okay, thank you very much, Sylvia. We do not have any public comments on agenda items in person. Do we have any online? None online either. We'll now move to the approval of the minutes for the June 6, 2025 special election board meeting. Are there any corrections or additions to the minutes? If none, the minutes stand approved as presented. We have 5 agenda items on the agenda for today. The first one is the voting system malfunction report approval, and this is a report that is submitted after every election. So I'm going to ask Ann to go over what the report is and how she divided up the categories for the report.
Thank you. Good morning. So yes, this is based on the primary that we just had in May. The Department of State gets this report, and it's basically a report of any issues that we had with voting machines on that election. And we get the information from poll workers. We ask them to fill a form out for us with any instances that anything that occurred during the day. Or we also go into our tracking system where we send out technicians, and we use that also for information. So basically, the only issues we had this election were with the express vote ballot marking device. We had 10 different precincts reporting instances, different kinds of occurrences. Most of them were repeatedly needed to restart, and we've had that in the past as well. We also had 2 cases where they weren't functioning on the startup. The technician replaced those 2, and I believe there were 2 that were repeatedly jamming as well, which were replaced. So basically, we have 10 instances that we reported, and all but I believe 2 of them were replaced. The other 2 express votes were just able to be set aside, and the voters could use other ones. So basically, there wasn't a big impact to voting or no impact to voting because there were other express votes available, but we reported to the state just because it's repeated errors. So we will submit this, that it didn't prevent or the casting of ballots or delay the casting of ballots or tabulation. But we did note that this did happen.
Okay. Just also to note, this is these issues are also reported to ES&S, which is the equipment provider, and we're working on seeing what is causing this in the machines to be able. We want to make sure that we're addressing them and trying to get them fixed, especially before next year's elections where we have a larger turnout. So it is something that we do look into, report it, but also want to make sure that we're addressing any issues that might be causing them to do that. Mm-hmm. And just also, and something you had mentioned, there's some of them that need to be turned off and turned back on.
Correct.
These machines do not store any information on there, so you can turn them all on and off as many times as you want.
That's right.
To reboot them. It's kind of like when I have an issue with my computer, I call IS, And I always know the first thing they're going to say,
Oh.
did you restart your computer? I said, oh, okay. So same thing, he's
Right.
rebooted, but there's no vote stored in there. That's just a ballot marking device. So there's really no information that gets lost when they're rebooted.
Correct. You are correct. Yes.
Okay, so we need a motion to approve the report.
Mr. Chairman, I move to authorize the submission of the voting system malfunction report for the 2025 municipal primary to the Department of State.
Second,
Okay.
There we go.
Okay, we have a motion and a second. Any discussion? All those in favor signify by saying aye.
aye.
None opposed. The motion carries. Okay, item number 2, and just if you weren't aware, Commissioner Linebaugh is joining us virtually. Item number 2 is polling place accessibility survey, and this is a survey that is done on an annual basis. So we're going to authorize execution of the survey of polling place accessibility for the elderly and persons with disabilities to the Department of State. And just to make clear, all polling places are accessible, are modified to be accessible on election day. Yeah.
Right. So you're correct. That's what the survey is asking. How many polling places do we have in our county? We have 202. And as Commissioner Rivera noted, they are all accessible or will be modified or were modified to be accessible. So we submit that report along with a spreadsheet detailing every polling place and whatever modifications are necessary.
Mr. Chairman, I'll make that motion.
Second,
We have a motion and a second. Any discussion? All those in favor signify by saying aye.
aye.
None opposed. The motion carries. Item number 3 is the discussion and authorization of the submission of the application for the Election Integrity Grant, also known as Act 88, for funds to be utilized for the November 4, 2025 municipal election and the May 19, 2026 general primary.
So the window for the application for this Act 88 funds is August 1st to August 15th. We just like to proactively get the board's approval to go ahead and apply for it when it does open. And typically, I can tell you that in 2024 this year, we did receive $1,375,000. So it's significant funding.
Mr. Chairman, I'll make that motion.
Second,
We have a motion and a second. Just add something to that. The amount that we get, we put a request in, but the amount that we get is determined by DCD, and it's based on the amount of pool that there is for that and how many other counties apply for that as well. So it could be a little bit more, it could be a little bit less. I believe it's all but maybe 3 or 4 counties throughout the Commonwealth apply for the Act 88 grant money. And if you notice, the interesting thing, it doesn't run a calendar year for the primary and general. It's a fiscal year, which covers the general and then the following primary. But as long as we get the money, I think that's what matters, right?
Right.
Okay, all those in favor signify by saying aye.
aye.
None opposed. The motion carries. Item number 4 is discussion regarding the handling of campaign signage and advertising complaints. At our last board meeting, we had the discussion as to say, okay, if someone does not comply with the required signage and advertising disclosures be it on a billboard, be it on a text campaign, on an email campaign, whatever it may be under signs, what direction should the staff at elections have as to what needs to be the remedy for that? We had discussion around that. We asked the staff to go back, have discussions with our solicitor, and come up with a policy around that. And that's what we're going to be discussing today. So Ann?
I could do it. Yep.
Okay.
So as Commissioner Rivera noted, Cody, Alexa and I met to discuss and establish guidelines for any campaign signage or advertising complaints that the Election Services Office receives. And we decided that for complaints received, the corrective action should be equal to what the initial infraction was. So for example, if there's a sign lacking a disclosure, which would indicate who paid for it, the candidate must place a label with the proper disclaimer on the campaign sign. And we further talked about a letter. If a letter is sent without referencing who paid for the mailing, a remedial letter should be sent to the same recipients with the correct information included. Same goes for a text message, any political advertisement in a text message. If it's unclear who paid for that ad, a corrective text message should be sent to the same group. If an advertisement is posted on a social media platform, again, without disclosure of who paid for it, another posting should be made with the correct disclosure. And lastly, if a phone call was made without a proper disclaimer, another phone call must be made including that information. We decided that the Election Services Office should receive evidence of the remedy, pictures, copies of letters, copies of text messages, et cetera. Whatever the remedy was can be sent to our email account, the Election Services, and we can make that clear to the candidate. And we decided that we should give them a time frame. So we came up with 7 days or before Election Day, whichever is a shorter period of time for the remedy to, be in place. And if we don't receive notification or evidence of the solution, at that point, we can bring it to the election board for discussion and possible submission to the DA.
Okay. Do you have a motion and a second to open it up for discussion?
I'll make the motion.
Second.
We
We have a motion and a second. Any discussion?
I certainly support and appreciate the work that you've done. Cody, does this any mention of this in the election law anywhere that talks about these issues?
In terms of remedying the issues,
Right.
there's not. Unfortunately, there's the statute that deals specifically with advertising, and that if the advertisement advocates for the election or defeat of a candidate, it must clearly and conspicuously state who financed that communication, in short. But there is no further discussion as to the process to follow to remedy it. There is a penalty associated. It's within that statute. It's a misdemeanor if you violate provisions of that statute. But like ballot curing, there's really not any guidance on advertising curing in this regard.
Okay, thank you.
This was done because, if you recall, this past election, we had different types of infractions. There really was no policy or guidance as to what the remedy should be.
Right.
To say to the candidate or whoever did it, well, this is a remedy, which will keep, stop from moving it on to referring it to the DA's office. We really didn't have that. So this
I mean, posting
is a
something,
standardized.
I guess the issue, someone posted it on social media and that wasn't appropriate. I agree. So
Hmm.
I support the decision.
So,
Any further?
Mr. Chairman, just
Yeah.
if you can explain, Cody, how in the case, I'm not going to say the name or the township, in the case that we're referencing where the disclaimer was missing on the mailing piece, what is the remedy? Just for clarity.
So in that case, where a letter was sent to residents of the township in question, which advocated for the election of a candidate, the remedy here would be to send an additional letter that essentially corrects the issue. So it should essentially state that a mailing was previously sent out. That mailing did not contain the requisite paid for disclaimer on it. And that communication in question was financed by blank, whoever it may be. So the remedy would be sending a separate letter in that issue, which identifies the error and corrects it. And the letter should be sent to the same mailing group as the original letter was. So if the original letter was sent to 1,000 people, the remedy would be to send a letter to those same 1,000 people, just to ensure that the individuals who received the first communication also received the second communication.
Okay. And then secondly, the time, 7 days before the election or whichever shorter or something it said like that. So if it was happened 4 days before the election, it's 4 days, not 7 days. The question is, in a mailer, it's going to take you longer than that to remedy. And in the case of somebody handing out material on election day, they're not going to be able to remedy unless they stop doing it immediately. How are we addressing those scenarios?
So I think in those scenarios, what the intent behind the 7 days or prior to the election was to essentially not allow somebody to send something out within, 2 days before the election and then be able to send the remedy out after the election, after it occurred, after the voters already received the incorrect mailer. So I would agree in that circumstance, if somebody were to send a letter that was received 3 days before the election or a text message, the night before the election, it's likely that in that situation, they're not going to be able to remedy the issue. But hopefully this serves as some sort of deterrence that if individuals are going to send communications
Okay.
out in the days following that, if they do it and there's not an opportunity for them to remedy, then likely, and it's always a situational dependent, but
Sure.
likely what we're going to do is probably recommend that be referred to the district attorney's office. So hopefully in that regard, there is some sort of deterrence aspect served by that verbiage.
Thank you.
Any further discussion? All those in favor signify by saying aye.
Aye.
I,
None opposed. The motion carries. The last item is an update and discussion regarding the Genser v. Butler County matter pertaining to a voter's ability to vote by provisional ballot if a voter's mail-in absentee ballot was rejected for an error. We've had discussions around this numerous times before today, but we just want to provide an update around this and open it up to any further discussion. Cody.
Thank you, Commissioner. So as you recall, in October of this past year, the Pennsylvania Supreme Court issued a ruling in the Genser v. Butler County matter, and the case pertained to a voter's ability to vote by provisional ballot if the voter's mail-in and absentee ballot was rejected for an error. In that specific case, it was specific to the lack of a secrecy envelope in the absentee and mail-in ballot. What the PA Supreme Court found is that Butler County correctly rejected the mail-in and absentee ballot because it was a naked ballot, didn't contain a secrecy envelope, but they erred in refusing to count the voter's provisional ballot that they cast after learning that there is an issue with their mail-in and absentee ballots. The PA Supreme Court, in deciding the issue, really focused on the fact that because there was a way to ensure that this wouldn't be a scenario of double voting, i.e., the provisional ballot would only be counted if their mail-in and absentee ballot were rejected. The court couldn't identify any voting principles that were violated by recognizing the validity of one ballot cast by one voter. If you remember, this decision was in line with our rationale when we discussed this issue shortly after the Ball v. Chapman decision was issued. In that case, the board had to decide whether or not voters who previously submitted mail-in and absentee ballots would be allowed to submit provisional ballots. And generally, in that circumstance, this board allowed voters to do that under the theory that we are able to confirm that only one of those votes is going to be counted. It's not going to be a double voting issue. I think it's also worth noting that another point within the Genser decision was the PA Supreme Court also looked at the affirmation requirement on a provisional ballot that requires the voter to state that this is the only ballot that I have, quote, cast in this election. And what the PA Supreme Court found in that regard is that when a mail-in or absentee ballot is declared void, so for lack of a secrecy envelope, that ballot has no legal effect. And because that ballot has no legal effect, the voter or the elector fails to, quote, cast a provisional ballot. That's what the PA Supreme Court found in that circumstance. So the Genser decision was the controlling law for this past election. Shortly after that decision was issued in late October, the RNC, if you recall, filed an emergency application to stay that decision pending writ of certiorari to the U.S. Supreme Court. In early November, the PA Supreme Court denied the emergency application for stay, so the decision wasn't stayed. It was good law during the last election. In January of 2025, sorry, I meant not this past October, October 2024. In January of 2025, so this past January, the RNC petitioned for a writ of certiorari to the Supreme Court of the United States, asking the Supreme Court, the U.S. Supreme Court, to review this decision on federal constitutional grounds. In early June, so right around a month ago, the Supreme Court denied the writ of certiorari. So they declined to hear the case as a whole, hear the merits of the case. So what that means is that the Genser decision from the PA Supreme Court remains good law in Pennsylvania and will remain the law in the process that we follow with regard to provisional ballots of voters whose mail-in and absentee ballots were rejected. So we'll continue to follow that decision absent any developments in the law or case law that would change those considerations.
Mr. Chair, I
Thank
have
you.
a question.
Yep.
So Cody, I think I hear from the decision, the Pennsylvania Supreme Court decision, that they, in a little bit of a backwards way, addressed the issue of a person saying, you know what, I don't know if my mail-in ballot's going to count, so I'm going to go vote provisional anyhow. If they do that, based on what I heard you describe, and their mail-in ballot was valid, they then have violated that affirmation oath. Is that correct?
So I think that's likely accurate, and we had previously discussed that specific instance, and we were actually kind of keeping an eye on that for this past election. Really, the issue in that regard is when a voter would cast a provisional ballot without prior notice of whether or not their mail-in or absentee ballot would have been rejected. And if it's ultimately, or if they cast a provisional ballot and they receive notice that their mail-in or absentee ballot, was accepted and would be counted. So that is a unique circumstance. Generally what the court focused on in the Genser matter was a voided mail-in or absentee ballot cannot be given legal effect, so therefore that ballot's not counted, which raises the question, if it's not ultimately voided, what does that mean in terms of casting? And it does raise a question in that regard, and that is something that we were keeping an eye on for this election. To my knowledge, in this election, we did not have any ballots that we identified that fell into that category. If we do, the plan would be to discuss it at a future election board meeting before the board to further discuss that specific point, and along with a recommendation of what we should do with these ballots.
Thank you.
So that didn't happen this last election, that circumstance. What about previous elections? It's occurred before? Once, twice?
I'm sure at some point
Yeah.
it's probably happened. Whether a voter just wants to make sure their ballot counts and does it out of an abundance of caution. The Ball v. Chapman decision, voters believe their mail-in and absentee ballots were going to be counted, and then that was reversed. So a lot of them went to the precincts to cast provisional ballots.
Okay.
So there's a lot of considerations that go along with it. Such as a voter could go to the precinct, they could submit a mail-in or absentee ballot and get, a notice from election services that they received their mail-in or absentee ballot. Not necessarily that there's an issue with it, but it was received. But we're only going to know if that's a naked ballot on election day. So it's possible that if a voter goes to the precinct in that circumstance, they're not yet going to know it's rejected. So there's a lot of different considerations here, but it is something we're cognizant of, and something that if it does happen in the future, we're going to take a closer look at and present it to the election board.
Okay, any further discussion? Okay, thank you very much. We'll now move on to the election director's report.
So I can mention that we sent out about 3,300 NCOA or National Change of Address notices to voters probably about a week and a half ago. This is part of our listserv maintenance that we do every summer. We're just asking these voters, this is information we've received that they may have moved. So we're asking them to either confirm their address or let us know of their new address. And they have by law 90 days before the next election, which is August 6th. To respond to us. Later in the month, we will send out 5-year notices to voters who have been inactive for 2 federal general elections. Again, all part of our list maintenance that takes place during the summer. Just a reminder that Monday, July 7th is the deadline for write-in winners to file acceptance paperwork in our office. If they do not, we cannot add them to the ballot for November. We have received about 74 candidates' paperwork out of about close to 100, right? So still have a few more to go, but Monday is the deadline for that. And that's all I have.
So, Ann, was the national change of address, you send it out, people should respond, yes, I moved, no, I didn't move. If there is no response, what happens?
Right. So at that point, and Sylvia can correct me if I'm wrong, at that point, a voter is moved to an inactive status. And then we track them for the inactivity. They are still able to vote. There's, they just have to fill out that affirmation at the polling place.
Before they can actually vote.
Correct. But they can on election day, or they can sign that affirmation on their application for a mail-in ballot.
Okay. All right. Any questions for Ann? All right. General comments from the board regarding current election-related issues. Okay, hearing nothing, we will move on to public comment. We have one person in person. We have Jeff Wolf. Jeff, if you want to come up, state your full name, your municipality, you will have 3 minutes, and Sylvia will be the timekeeper.
All righty. Good morning. My name is Jeff Wolf, Brecknock Township. Some recent news regarding foreign threats to elections. A former CIA agent, Gary Bernstein, recently sent a letter to President Trump regarding a federal prisoner, Venezuela's General Hugo Carvajal, who served under the late President Hugo Chavez. Bernstein is asking Trump to intervene to postpone Carvajal's trial for drug trafficking because he may be willing to cooperate with authorities prior to going to trial because he has knowledge of Venezuela's role in interfering in the 2020 U.S. election and other global election fraud. The Southern District of New York released a sealed indictment from October of 21, which revealed how Iranian nationals hacked into the voter rolls of the state of Alaska and stole voter identities, names, driver's licenses, social security numbers, and so forth, in order to fill out a UO-CAVA ballot registrations. FBI Director Kash Patel made a recent announcement that he turned over evidence to Senator Chuck Grassley showing that the FBI had been aware of CCP interference in the 2020 presidential election, but recalled their report to the intelligence agencies allegedly because then FBI Director Wray was downplaying foreign election interference in his testimony to Congress around that time. The evidence, a redacted FBI report to Grassley, identified the CCP's role in manufacturing and exporting driver licenses to Chinese residents in the United States to create fake identities in order to vote mail-in ballots to benefit Biden. Safeguard American Voter Eligibility Act, or the SAVE Act, passed the U.S. House in 2024. The bill prohibits states from accepting and processing an application to register to vote in a federal election unless the applicant presents documentary proof of U.S. citizenship. In applying for federal funds via the Election Integrity Grant Program, I urge the Election Board to anticipate the passage of the Federal SAVE Act this year, which could impact the voter eligibility and registration process, especially if documentary proof of citizenship is required for voting in a federal election, the 2026 primary. IDs, driver's licenses, social security numbers are currently being provided to non-citizens, and the federal voter registration form is essentially an honor system requiring a checkbox to confirm citizenship. How Act 88 funds could or should be used if documentary proof of U.S. citizenship is required to vote in the 2026 primary, I do not know, but at least a discussion should be taking place between the board and the Pennsylvania Department of State. Thank you.
Jeff has it timed almost down to the second there. All right, thank you, Jeff. Okay, do we have any online comments?
I make a motion, we adjourn.
I will second that.
Second,
The meeting is adjourned. Thank you, everyone. Have a great 4th of July and a great weekend.